Imagine this for a second. It's August 13th, 1986. For Michael Morton, that day wasn't just bad, it completely shattered his life. His wife, Christine, she'd been brutally murdered. And then, incredibly, he ends up spending the next 25 years locked up for it, a crime he absolutely did not commit. But here's the part that it floors me. The proof, the evidence that could have cleared him, it was right there, sitting in the prosecutor's files the entire time.
Yeah, it's almost unbelievable.
We're talking about an 8-page transcript. His own 3-year-old son, Eric, telling his grandmother he saw a monster, his word, kill his mom, and that his dad, Michael, wasn't even home.
A 3-year-old witness.
Exactly.
Yeah.
And there were neighbors who saw a guy in a green van hanging around the house beforehand. And, get this, Christine's credit card, used after she was murdered while Michael was already in custody.
Which clearly points somewhere else.
Clearly. But the prosecutor, Ken Anderson, he hid all of it and later gets elected judge.
That's deeply troubling.
And the tragedy just compounds. While Michael's inside, the real killer murders another woman, same horrific way. It wasn't until 2011, with DNA, that Michael was finally exonerated, and the court found Anderson deliberately concealed evidence.
25 years.
25 years. Oh, look, this isn't just one awful story, as heartbreaking as it is. Michael Morton's case, it really shows a massive systemic crack in how our criminal justice system deals with evidence, a fundamental flaw.
Right. And right at the heart of that flaw, you have this constitutional rule called the Brady Rule. It comes from a 1963 Supreme Court case, Brady v. Maryland. And what it says, basically, is prosecutors have to turn over all evidence that's favorable to the defense,
Right.
even if the defense doesn't ask for it specifically.
Why? What was the court's thinking there?
Fairness. The court said, and I'm paraphrasing a bit, society wins not just when the guilty are convicted, but when criminal trials are fair. It's about making sure the trial process itself is just.
Okay, so for this deep dive, our mission is really twofold. First, let's unpack this flaw, look at the human cost, which is immense, and then explore a really fascinating potential solution using technology, maybe AI, that could genuinely revolutionize things.
Sounds like a plan. To really get why cases like Morton's happen, we need to dig into what Brady actually demands.
Okay, let's do it. What kind of evidence are we talking about?
Well, the courts have sort of broken it down into 3 main types that prosecutors must disclose. First up is what's called exculpatory evidence.
Exculpatory, meaning?
It tends to prove the defendant is innocent. Think witness statements pointing to someone else, maybe forensic evidence like DNA or fingerprints that don't match the accused, or maybe video showing the defendant was somewhere else entirely, police reports about other leads that were never followed up, anything really that goes against the prosecution's story.
Right, the stuff that directly says it wasn't him. That seems pretty straightforward. Why is that so vital beyond the obvious?
Well, it goes to the absolute core question, doesn't it? Guilt or innocence? If there's evidence pointing away from the person charged, the whole case might be built on sand. Without it, you're judging someone based on, well, an incomplete picture. Or maybe even a totally wrong one.
Okay, so exculpatory is number 1. What's next?
Second is impeachment evidence. Now, this stuff doesn't directly prove innocence, but it casts doubt on the credibility of the prosecution's witnesses.
Ah, so it's about showing the jury maybe they shouldn't trust a particular witness.
Exactly. Like maybe a witness said something different before trial, or maybe they have a criminal record themselves, or pending charges, or maybe there were deals made, payments or promises for their testimony, even evidence they've lied in other cases. It's all about context for the jury.
So it helps the jury weigh how reliable that testimony actually is. Makes sense.
Precisely. If a key witness is testifying because they cut a deal on their own charges, the jury absolutely needs to know that to figure out how much weight to give their words.
Right. Okay, so exculpatory impeachment.
Right.
What's the third category?
The third is mitigating evidence. This is information that might lead to a lighter sentence if the person is convicted.
So even after guilt is decided?
Yes. Things like evidence of mental illness or maybe diminished capacity, circumstances that might suggest a lesser charge was more appropriate, or even character evidence showing the person is maybe unlikely to reoffend.
Got it. And you mentioned earlier, this isn't just about what the lead prosecutor knows personally, right? It's bigger than that.
Oh, much bigger. The duty covers evidence known to the entire prosecution team. That means the police involved, investigators, the crime lab technicians, forensic experts, basically anyone acting on behalf of the government in that case.
Wow.
The Supreme Court actually said the prosecutor has a duty to learn of any favorable evidence known to others acting on the government's behalf.
That sounds like a huge burden, a duty to learn. How does that play out in practice? Where do things break down there?
It's a massive challenge, honestly, logistically and ethically. Think about a big, complex case. Multiple police departments, maybe federal agencies, dozens of officers, investigators, lab reports, terabytes of digital evidence.
Yeah, just coordinating sounds like a nightmare.
Exactly. Making sure every single scrap of potentially helpful information, maybe a quick note in some officer's notebook, actually gets identified and shared. It's incredibly difficult. Breakdowns happen in communication gaps, different agencies not talking. Sometimes it's just oversight, honest mistakes. But sometimes it's deliberate. Someone on that team decides withholding something helps secure the conviction they believe is right.
And that brings us back to the core problem, doesn't it? The system sort of puts prosecutors in this impossible spot.
It really does. It's the Achilles heel. They're legally required to actively search for and hand over information that could potentially sink their own case, that could help the other side win. There was this one prosecutor quoted pretty candidly saying something like, "Look, did he do it or not? If I think he did it, why should I help the defense discredit my witness before I absolutely have to?"
Wow. That quote it lays it bare, doesn't it? It sounds like you're asking someone to work against their own goal, which is usually to win the case. Is that the fatal flaw, this built-in conflict?
That's absolutely the core of it. Legal scholars call it the Brady paradox. You've got this crucial constitutional right, but its enforcement relies almost entirely on the good faith of one side in an inherently adversarial system.
It's like asking, I don't know, a boxer to tell their opponent where they plan to punch next.
Exactly. The ideal of fairness clashes head-on with the practical realities and pressures of that adversarial system. And the results, well, they can be devastating, as we saw with Michael Morton. And sadly, his case isn't some rare outlier.
Right, you mentioned other examples.
Yeah, take Senator Ted Stevens back in 2008, convicted on felony counts related to ethics stuff. The prosecution's star witness was this oil executive, Bill Allen. But the jury never heard that Allen had initially told prosecutors the value of some renovations was way lower, like $80,000 versus the $250,000 he claimed at trial.
A huge difference.
Huge. They also didn't know Allen had apparently pressured a 15-year-old girl to lie under oath in another matter, or that his key testimony against Stevens only sort of came to him on a flight, apparently, after some prodding by an FBI agent.
Unbelievable.
The judge eventually threw out the conviction, but Stevens had already lost his Senate re-election. A special prosecutor later found systematic concealment of significant exculpatory evidence. Systematic.
And it's not just political figures.
Not at all. Look at New Orleans. Reports show at least 36 convictions overturned because of prosecutorial misconduct, with evidence allegedly buried in dozens of cases going back decades. Or Brooklyn John Juca spent 15 years in prison before a court found prosecutors actually lied about a deal they made with a jailhouse informant who testified against him.
15 years based on a lie.
And Virginia, Justin Wolf's capital murder conviction, overturned after a key witness admitted police basically strong-armed him and fed him the information he testified to.
So the common thread here is the evidence existed, it was somewhere in the government's files, but the system, relying on people acting against their perceived interests, failed to get it to the defense.
Precisely. The adversarial structure itself created the conditions for failure.
Okay, so if relying on good faith is the fundamental problem, what's the fix? How do we design a system that ensures this information gets shared instead of just hoping it does?
Well, this is where technology could potentially make a huge difference. The idea isn't about trying harder to make people act against their nature. It's about changing the system itself. Imagine a mandatory AI-powered evidence management system. The goal is to make Brady compliance automatic, transparent, and, well, unavoidable.
An AI system. Okay, that sounds futuristic, maybe a little sci-fi. How would that actually work in a real case? Day-to-day for the lawyers.
It's actually pretty practical when you break it down. Think of it like this. Every single piece of evidence, every police report, witness interview, lab result, investigator's note, email has to be digitally logged into this central system to be admissible in court.
So if it's not in the system, you can't use it at trial.
Exactly. It creates a single comprehensive repository. Then the AI gets to work. It's programmed to analyze everything using pattern recognition, natural language processing, cross-referencing against legal precedents. It would automatically flag items that could be Brady material, maybe inconsistencies between different witness statements, background information that could impeach a witness, evidence pointing to other suspects, forensic results that don't fit the prosecution's theory.
Okay, so it's finding the potential needles in the haystack. What about that whole prosecution team problem, making sure info from the police or the lab gets included?
The system would address that directly. Because everything has to be logged, it inherently pulls information from all parts of the team. And it would provide real-time compliance monitoring. It could cross-reference what the prosecution says it shared with the defense against the complete digital file, creating an automatic audit trail. It could flag discrepancies before a trial even starts.
That's automatic audit.
Yeah, it could even potentially help both sides with analysis pointing out gaps in the investigation, suggesting maybe more forensic testing is needed, or highlighting patterns across cases that a human might easily miss.
Okay, but here's the crucial part, right? The AI flags something. What happens then? Does the prosecutor still get to decide whether to turn it over?
No. And this is the key difference. Once the AI flags evidence as potentially Brady material, it would automatically go into a mandatory disclosure queue. Defense counsel would get immediate access. It removes that prosecutorial discretion, that conflict of interest, from the equation.
Wow. Okay, that is a fundamental shift, taking the human judgment and the human conflict out of that specific step.
Exactly. It moves from a system based on trust and discretion to one based on mandatory, verifiable transparency.
So let's apply that back. Michael Morton's case. Their little boy's statement, the credit card use.
Instantly flagged. The moment they're entered, the AI sees the direct contradiction to the prosecution's narrative. Boom. Mandatory disclosure.
Decades saved. Another woman's life potentially saved.
Absolutely. Or Ted Stevens. The AI cross-references Allen's statements, flags the massive inconsistency in the renovation value, flags the reports about pressuring the teenager, the FBI agents prodding. It all becomes visible. And think bigger picture. The AI could spot patterns, like, say, a specific police officer consistently having witnesses who later recant, or a jailhouse informant suddenly remembering crucial details in multiple unrelated cases, things a human reviewer, looking at just one case file, might never connect.
You mentioned earlier that video evidence is a huge area for these violations, and cameras are everywhere now. Traffic cams, businesses, doorbells, police body cams. That's a mountain of data.
Yeah.
How does the AI tackle that specific challenge?
Yeah, the sheer volume of video is overwhelming. The AI system could help in several ways. First, automatic inventory. It could potentially map known camera locations near crime scene traffic lights, registered businesses, etc., and flag if expected footage is missing. Hey, there's a traffic cam on that corner. Where's the footage from that hour?
Preventing the, oh, we didn't know there was a camera issue.
Right. Second, content analysis. Obviously, you still need humans, but AI could potentially scan hours of footage, maybe flagging sections that contradict witness statements or police reports already logged in the system.
Or verifying timelines, cross-referencing timestamps on video with when people claimed events happened.
Exactly, detecting discrepancies automatically. And crucially, preservation. The system could issue automatic preservation alerts for relevant video sources.
Preventing that, oops, it got recorded over problem.
Precisely. Instead of relying on someone remembering to grab the footage before the system auto-deletes, you'd have automated notices, maybe even backup requirements triggered by the system based on the case details. It builds in safeguards. There was a recent case, I think in Texas, where a murder charge got dismissed during the trial because it came out police had cell phone video that contradicted their main witness. The defense only found out by chance.
Mid-trial.
Mid-trial. An AI system logging all evidence should have caught that discrepancy way earlier. It's about creating transparency by design, not relying on luck or good faith.
The whole concept is incredibly powerful. It really feels like it could be a game changer. But let's talk reality. The legal system isn't exactly known for a rapid adoption of new tech. How politically feasible is something like this, especially given the costs involved?
It's a fair question. Change is hard, especially in established institutions. But here's where things get interesting. The crisis in many county jails right now actually creates, I think, an unprecedented political opening. Well, take Harris County, Texas, Houston, third largest jail system in the country. Their official capacity is around 9,500 beds, but they're routinely holding over 12,000 people.
12,000, that's massively overcrowded.
Hugely. And it leads to terrible outcomes. Higher assault rates, more deaths in custody, something like 24 deaths in 2022 alone. Reports say 80% of the inmates have mental health issues. They're under federal scrutiny, facing potential lawsuits, maybe even federal intervention.
Okay, so the pressure is already immense in places like that.
Exactly. So for counties like Harris or others facing similar crises, overcrowding, federal consent decrees, lawsuits, this AI system isn't just some nice-to-have tech upgrade. It becomes a potential solution to multiple urgent problems at once.
How does it connect directly to those problems?
Well, think about it. Fewer wrongful convictions means fewer multi-million-dollar civil rights lawsuits down the line. That's reduced liability. Faster identification and disclosure of evidence, especially exculpatory evidence, should lead to faster case resolutions, quicker dismissals, or pleas. That reduces pretrial detention time, which directly attacks the jail overcrowding problem.
Right, fewer people waiting years for trial.
It demonstrates proactive compliance with constitutional mandates, which helps satisfy federal monitors or court orders, and by making evidence handling transparent, it starts rebuilding public trust, which is often shattered in these situations. It hits multiple pain points.
Okay, that makes the political calculus look different. So how would you actually roll it out? You can't just flip a switch across the whole country or even a whole state.
No, absolutely not. You'd need a phased approach, probably starting with pilot programs. Phase 1. Target counties with known compliance issues or those under consent decrees. Start with high volume, but generally lower stakes cases. Think drug possession, simple theft. These make up a huge chunk of the caseload anyway and let you test and refine the system.
Learn the ropes with less complex cases first.
Right. Phase 2. Maybe offer it as a voluntary opt-in for prosecutor offices and defense bars in certain areas. Let them see the benefits, build buy-in, create champions for the system.
Demonstrate its value before making it mandatory.
Exactly. Then phase 3. Once it's proven effective and refined, you gradually expand it to more serious crimes, and eventually perhaps make it the standard across jurisdictions. You definitely target the big urban areas initially: Cook County in Chicago, LA County, Harris County in Houston. They have the volume, often the documented problems, and the resources to potentially implement something like this. Success there would be hugely influential.
Okay, that sounds like a plausible path. But what about the hurdles beyond just getting politicians on board? You mentioned legal frameworks.
Yeah, there are definitely challenges. While Brady itself is constitutional, the specifics of how disclosure happens are often governed by state statutes or court rules. So you'd likely need legislative changes to mandate a system like this.
Is there any precedent for states strengthening Brady requirements?
Oh, yes. Texas actually passed the Michael Morton Act after his exoneration, which requires prosecutors to disclose more evidence and earlier than the federal Brady standard demands, so states can act to improve discovery.
Okay. What about the lawyers themselves? You've got prosecutors, defense attorneys. How do you get them trained and comfortable using this? And is there a risk they become too reliant on the AI, maybe missing human nuances, or concerns about the AI being a black box?
All valid points. Training would be massive and crucial. It's a new way of working. Regarding reliance, the goal isn't for the AI to replace lawyers' judgment. It's a tool to assist judgment, to surface things, to ensure completeness. Lawyers still need to analyze, interpret, strategize, argue. And the black box concern is real. Any AI used in justice has to be transparent and auditable. We need to understand why it's flagging something. That needs to be built into the design. Privacy and data security are obviously huge considerations, too.
And cost. This sounds expensive up front.
It would be. Significant investment needed in software, hardware, training, ongoing maintenance. But you have to weigh that against the current cost.
Cost of getting it wrong.
Exactly. What's the cost of incarcerating an innocent person for 25 years? What's the cost of the civil lawsuit that follows? What's the cost of public faith when these cases come to light? The cost of wrongful convictions financially, socially, morally is astronomical. Prevention, even if expensive up front, is almost certainly cheaper in the long run.
It's hard to argue with that math. When you think about Michael Morton losing 25 years, Senator Stevens losing his career, dying before his name was fully cleared, Christine Morton's killer being free to kill again, the cost of inaction is just devastating.
It truly is. And every Brady violation, whether deliberate or negligent, chips away at the legitimacy of the entire justice system. When the process relies on adversaries hopefully playing fair, when constitutional rights become dependent on individual goodwill, the system is fundamentally fragile. It fails everyone involved: the wrongly accused, the victims who don't get justice, and society, which loses faith.
And the technology to build a more robust system, it's not science fiction anymore. Pattern recognition, automated monitoring, managing huge data sets, Transparently, these tools are being used in finance, healthcare, logistics.
Exactly. They exist. They work. The question isn't, can technology help fix this? It clearly can.
The question is, will we use it?
That's it. The criminal justice system really feels like it's at a crossroads. We can stick with the status quo, rely on the honor system, and just hope these tragedies don't keep happening. Or we can embrace technology to build in the transparency and accountability that the Constitution demands.
And for those counties really feeling the pressure, the overcrowding, the lawsuits, the federal oversight,
Mm.
this isn't just about fixing Brady. It's a chance to tackle multiple crises at once.
It's a genuine opportunity for them to lead, to show that you can reduce wrongful convictions, make the system faster and more efficient, and restore public confidence all at the same time. It's potentially a win-win-win.
Yeah.
So ultimately, the question isn't about the technology's capability. It's about our collective will. Do we have the will to implement a solution like this before the next Michael Morton story unfolds? Before another innocent person loses decades of their life?
It feels less like an option and more like a moral imperative, doesn't it? To build a system that actually lives up to the promise of justice. Definitely something to think about. What stands out to you about this challenge and this potential path forward? Something to chew on as you go about your day.